and welcome to this, the inaugural Bowmans Firmwide Dispute Resolution Moot. The Moot brings together lawyers from our offices in Sandton, Cape Town, Nairobi, Mocha, Dar es Salaam, and involves lawyers ranging from candidate attorneys and pupils through to the managing partner in Tanzania. We will shortly give the teams an opportunity to introduce themselves. I would like to thank Claimant Makiva, Ashley Graham, and Kabwela Chisaka for their involvement in the conceptualization and development of the moot. We would also just like to let the parties know that in addition to the bragging rights, there is a prize up for grabs for the winning team. On our panel this morning is Mr. Wilbert Kapinga, Managing Partner of our Tanzania office. Wilbert has broad-ranging experience in M&A, banking and finance, but most relevant for today is his expertise and experience in international arbitrations involving bilateral investment treaties. We also have Mr. Clement Makiva, partner in our dispute resolution department in the Sandton office. Clement is experienced in high court litigation, private arbitrations, and mediation, and recently completed his master's in international dispute settlement from the Graduate Institute of International and Development Studies at the University of Geneva. That's my intro. I'll hand over to the panel, but what I thought, if an agreement, is if the members of each team could just turn on their cameras and introduce themselves, and perhaps we could start with the representatives for the claimant and then move on to the representatives for the respondents, if that is in order.
Yes, thank you.
Thank you, Bianca. That is in order. First, perhaps if I could just indicate that this is exit case number ARB/005/2021. You have before you a panel constituted of myself, Clement Mkiva, as well as Dr. Wilbert Kapinga. We have been ably assisted by the Secretary to the Tribunal, Ms. Bianca Masterton. And before we get to some housekeeping rules, if I could ask, please, the leader of the claimant team to introduce his or her team.
Thank you, Mr. Arbitrator. Thank you, Madam Secretary. By way of introduction, my name is Zawadi Lamini, and I am appearing together with my three colleagues, Mr. Suhail Mohammed, Ms. Tabiseng Selepe, and Mr. Barkley Odiambo. Together, Mr. Arbitrators, we appear on behalf of the claimants in this matter.
Thank you. If I could also ask the leader for the respondent team to introduce his or her team.
Yes, thank you, and good morning, Mr. Arbitrators. My name is Ayandan Kabinde. I appear on behalf of the respondent, being the government of Malaysia. I am joined by my learned colleagues, Mr. Jason Barb, Ms. Cara van der Pol, and Ms. Guku Tom.
Thank you, Mr. Nkabinde. And before we start with the oral submissions, just a few housekeeping matters for our gallery so that they are aware of how the proceedings will be structured. We will first have the respondent who will go first because they are alleging that the tribunal does not have jurisdiction. Then we will have oral submissions from the claimant, and then thereafter the respondent will have a few minutes for rebuttal. Each party has 45 minutes for their oral submission, and for purposes of the respondent, that within that 45 minutes, they also have to make their rebuttal. And how we thought the best way of going about each party's oral submission would be to afford each party 3 minutes of protected time, where the panel won't ask any questions of the party making submissions, but thereafter we will ask questions. And we've also asked the parties just to make sure that they've allocated their time sufficiently within each team so that we are within the time period set. Mr. Nkabinda, I believe that the respondent has the duty to begin, so over to you.
Thank you, Mr. Arbitrator. All commercial contracts exist on a spectrum, which is separated by a horizontal line. Below that line, we have our ordinary commercial contracts, and disputes which arise from these ordinary commercial contracts are ordinarily and adequately dealt with in terms of treaties, as well as the dispute resolution mechanisms set out in the contract itself. Now, above that line, we get what the parties will call an investment. And that word is derived from Article 25(1) of the convention, of the ICSID Convention. That being, or rather, which states that the jurisdiction of the center shall extend to any legal dispute arising out of an investment. So the issue at hand today is whether the salvage contract falls within the definition of an investment. The contract in question was a salvage contract concluded in August of 1991 between the parties. In terms of the contract, the claimant was to undergo salvage operations to recover the cargo of a ship called the Diana, which had sunk off the coast of Malaysia some 2 centuries ago. And in return for recovering the items, the claimant would be entitled to a percentage of the sale proceeds that would arise following an auction of the recovered items. Now, it's important to note in this case that the contractual claim has already been pursued by the claimant. In this regard, the salvage contract provided that clause 32.1, in terms of clause 32.1, the parties were required to resolve any disputes under the arbitration laws of Malaysia. It's also relevant that the respondent in this case is a party to a bilateral investment treaty with the UK and Northern Ireland. I'll explain in great detail the importance of that bilateral treaty. Now, of course, the claimant claims or believes that the salvage contract is in fact an investment for the purposes of the convention, and their submissions are based on the application of the Cellini test, and they also propose a more flexible test, which in substance would seem to either do away with or water down the factors set out in Cellini. However, properly construed, the claimant's approach would lead to all or most, if not all, commercial contracts being brought under the jurisdiction of ICSID. The respondent, on the other hand, of course, has an opposing view, and that is that the salvage contract is an ordinary commercial contract and is to be excluded from the meaning of the word investment under the convention. Of course, the onus is on the claimant to establish jurisdiction, and the parties have agreed in broad terms on the test to be applied. In this regard, the tribunal seems obliged to refer to the test established in Cellini versus Morocco, which requires scrutiny of 4 factors in respect of the contract. The first one being whether the contract contributed to the economic development of the host state, in this case, Malaysia. It requires a look at the risks associated with the contract, the duration of the contract, and finally, the parties' contributions in performing under the contract. Now, in advancing the respondent's submissions, I will first deal with the central proposition, being that ordinary commercial contracts must be excluded in order to maintain the appropriate legal order. I'll also term this, or I might also refer to this as the floodgates argument. I will then also deal with the salvage contract on its face, and how even on the face of it, and with consideration of its purposes, the salvage contract cannot be construed to be an investment. My team in turn—
Kabinde, sorry, I just have a preliminary question on some of your opening remarks. You said that the parties are in agreement that the Cellini test has to be applied in this matter. as you are aware, the tribunal is not bound by any other prior decision and can follow a completely different course. But if I'm understanding your submission correctly, you are saying because the claimant also agrees with you that the Salini test is to be applied in this matter, the tribunal is bound to apply the Salini test. Do I understand you correctly?
So perhaps bound is too strong a word, but in the respondent's view, it would be difficult for the tribunal to justify departing from the submissions that have been placed before it. And those submissions have been placed broadly in the four corners of the Salini test.
Okay, thank you.
Perfect. And then in turn, my colleagues will then deal with the actual application of the Salini test. In brief terms, Mr. Bob will submit that there was no economic development to the host state. Ms. van der Poel will point out that the risks associated with the contract are ordinary risks in ordinary commercial contracts. And Ms. Tom will deal with the duration aspect and point out that the duration is insufficient. So as pointed out, the central proposition is indeed that ordinary commercial contracts ought to be separated from investments themselves. Now, this is a point that the claimants do not necessarily engage with in any great detail in their written submissions. But in that respect, I would just simply point the tribunal to the instances of Joy Mining versus Egypt, Nova Scotia Power versus Venezuela, and broadly, actually, page 6, footnote 13 of our written submissions for a plethora of case law that supports the proposition. But the upshot of all of that is that a salvage contract, or rather, that we must recognize the distinction between an ordinary commercial contract and a contract that is to be considered by ICSID. And this leads me into the floodgates or legal order argument. Now, once again, I repeat that it is relevant that the word investment is in fact defined in the treaty to which I referred, the treaty being between the respondent, the UK, and Northern Ireland. Now, what's also important is that the respondent does not dispute that this salvage contract would fall squarely within the definition of that word. Now, Joy Mining is authority for the statement that there must be an objective definition in trying to identify what, or rather where a contract would fall. The claimants have relied on Bywater versus Tanzania, as well as Philip Morris versus Uruguay. They rely on it for the application of a flexible test. Now, notwithstanding that there might be a slight discrepancy between the parties' interpretations of those cases, Bywater sets down that a tribunal that has been asked to consider whether a contract falls within the definition of the word investment can simply rely on the wording contained in the treaty and simply import it into the meaning for the purposes of the convention. Now, the claimant, or rather the respondent, would like to point a few things out, 3 things out actually. The first is that the Bywater approach and the Philip Morris approach are both anomalies in a long line of case law that requires loyalty to the principles of, or to the principles set down in Salini and the likes of Joy Mining and the cases that I've just cited. But the impact of the Bywater approach is first, and on this stable legal order point, is that the dispute resolution mechanisms that are set out in treaties and contracts would then become redundant, because notionally, it would mean that a party would not have to defer firstly to what's to the contractual obligations, a party could always fall back on the fact that they can approach the center to argue a dispute. So in this case, as I pointed out previously, the claim had been pursued. It was found to have no merit. But in following the claimant's approach, what we would have is parties unduly getting a second bite at the cherry to relitigate a claim that has already been properly decided. But the effect of that is that it erodes the purposes of the convention, of the ICSID convention. Now, this purpose is set out in the preamble of the convention, but it requires, or rather, it holds that it was drafted for the purpose or in consideration of the need for international cooperation for economic development. And therein lies the obvious filter. So the upshot of all of this is that the tribunal must be circumspect in deciding which or what kind of contracts ought to be bought or ought to be considered by it, or what kind of contractual disputes ought to be considered by it. Now, on the face of the salvage contract, and this is my last point, paragraph 22 of the claimant's submissions, they purport, or rather, they submit that this is a close case, that this is a case that, because it is so close, must be determined flexibly on an application of the Philip Morris and Bywater principles, which of course I've already shown should not be followed because it would not be in the interests of any parties to do so. However, what is evident about this contract, before we even get to the Salini test and accepting the claimant's approach that the Salini factors be watered down, we must first look at the purpose of the contract. And nothing points to it being anything other than a run-of-the-mill salvage contract. And I must point out, or rather highlight, what was found in the Joy Mining case. And that is that just because a host nation is party to a particular contract, it does not elevate the status of that contract to put it above the line, as I had referred to earlier, or to bring it within the definition of an investment. But also, what I wish to point out is that in acting, or rather a clear indicator that emanates from the case law, is that the parties or the host state in that instance, or indeed the parties, were acting with a degree of sovereignty. So in this respect, in Binder versus Pakistan, we had an instance where the tribunal had to consider an M1 motorway project. And this, even on the face of it, even as I submit to the tribunal now, there's a project that was aimed at improving the infrastructure. And the same for Jean Denot versus Egypt, where we dealt with the dredging of the Suez Canal, the Suez Canal being an important tourist route. I mean, not tourist route, economic and trade route. And then again, in Czechoslovakia, where we dealt with agreements that related to improving banking infrastructure. So all of these in all of these decisions where jurisdiction was established, there was a degree of public importance that was evident in the contract itself. And this simply isn't evident in this salvage contract. So with all that said, Mr. Arbitrators, I will now hand over, assuming that there are no questions, I will hand over to my colleagues to deal with the true application of the Salini factors.
There is one further question for you, Mr. Nkabinde, before you hand over to your colleagues. You have distinguished between commercial contracts and an investment. Do you accept that a commercial contract can also constitute an investment?
Yes. So if I can just perhaps clarify, it is correct that a commercial contract can be an investment. The reason I use the word investment for this purpose is just simply because it falls within the language of the convention. But our proposition is not that the investment is separate from a contract. Instead, our proposition, I guess, is that an investment is a particular type of commercial contract.
Okay, so what the tribunal is called upon to do in this instance is to assess the commercial contract, being the salvage contract, to see whether it meets the requirements of an investment. Okay, thank you.
Thank you, Mr. Arbitrators.
The arbitrator, sir, as indicated by my learned colleague, Mr. Nkabinde, in order for the salvage contract to fall within the definition of investment under the Article 25, subsection 1 of the ICSID Convention, the claimant must establish, in conformity with the Salini criteria, the Salini jurisprudence, but there have been, in particular, a contribution, and that this contribution contributed to the economic development of Malaysia. I will be dealing with a more contentious factor of whether there was a contribution to the economic development of Malaysia. I will demonstrate to the tribunal that, firstly, if whether, as proposed by the claimant submission, there has been a contribution as a result of the performance of a salvage contract, this contribution, as per the ICSID jurisprudence, does have to be economic. Secondly, the salvage contract was not concluded by the parties with the intention to contribute to the Malaysia economic development. And finally, Mr. the Arbitrator, sir, there was no significant contribution to the economic development, and the salvage contract did not promote the economic development of Malaysia in a substantial or significant manner. Mr. the Arbitrator, sir, I will now deal with the claimant's submission. But contribution does not need to be economic. At paragraph 12 of the claimant's memorial, more precisely, the claimant submitted that the Salini criteria does not refer to economic contribution, but instead refers to any substantial commitment to the host state. The claimant relies on the commentary of the ICSID Convention by the Professor Schro, Christoph Schro, to have regard to non-economic contributions that the claimant had made to Malaysia under the salvage contract. First of all, the tribunal would note that at its preamble of the ICSID Convention, it is provided that the convention has been drawn up with a consideration, and I quote, of the need for international cooperation for economic development and the role for private investment therein, end of quote. Further, this requirement, i.e. of a contribution of an economic development, is fundamental to the existence of an investment. In the case, in the ICSID case, Mitchell and Congo, the award was annulled on the ground that activities of a US law firm in the Congo did not contribute to the state's economic development and did not, therefore, constitute an investment within the meaning of Article 25, subsection 1 of the ICSID Convention. Finally, the Professor Schro himself, in his book of 2001, the ICSID Convention, a commentary, said that there must be a positive impact, economic impact, on the host state's development to satisfy the Salini criteria and therefore constitute an investment within the meaning of Article 25.1. Mr. the Arbitrator, sir, the respondent therefore submits, but the salvage contract needs to contribute to the economic development of Malaysia to constitute an investment within the meaning of Article 25, Section 1 of the ICSID Convention. The arbitrator, sir, I will now turn to my second argument. Does the salvage contract was concluded by the parties with the intention to contribute to the Malaysia economic development? The salvage contract, as explained by my learned colleague, Mr. Kabinde, was entered into between the claimant and the respondent in August 1991 for the purpose of locating and salvaging the cargo called Diana. The salvage contract provided that the claimant was, amongst other things, required to utilize its expertise, labor, and equipment to carry out the salvage operation and to invest and expend its financial resources for the salvage operation. On the other hand, the salvage contract provided for the respondent to receive the sales proceeds of the recovered items and to thereafter disburse to the claimant the portion of the sales proceeds belonging and due to the claimant. Mr. the arbitrator, sir, at no material point in time, the intention of the parties nor the obligations under the salvage contract indicate that the intention of the parties was to enter into the salvage contract to contribute to the Malaysia economic development. In other words, the claimant cannot argue, but based on the substance of the salvage contract and the obligations provided therein, that this contract was concluded by the parties with the intention to contribute to the Malaysia economy. Mr. the arbitrator, sir, I will now submit that there was no significant contribution to the economic development of Malaysia. As per the ICSID jurisprudence, the claimant must establish that not only the salvage contract contribute to the Malaysia economic, but that contribution needs to be significant or made in a substantial manner. From a purely contractual point of view, the tribunal would agree. But in essence, any contract would have made some economic contribution to the place where it is performed. We all agree on this. However, that does not necessarily automatically mean that a contract is an investment within the meaning of Article 25, Subsection 1 of the ICSID Convention. At paragraph 12, at paragraph 13, apologize, of the claimant's memorial, the claimant submitted that during the salvage contract period, the claimant had employed, trained, and fed many Malaysian nationals. Here the question would be, does the fact of employing, feeding, training Malaysian nationals would constitute a substantial economic contribution to the Malaysian economy? If this may have benefited to the Malaysian public interest and economy to some extent, these benefits and any other direct financial benefits to Malaysia cannot be seen as significant contributions to the Malaysia's economy in the sense envisaged by the ICSID jurisprudence. For instance, in the award of Joe Mining and Egypt cited by my learned colleague in Kabinde, the tribunal held that to qualify as an investment, so to qualify as investment within the meaning of Article 25, one of the ICSID Convention, the contribution to the economic development of the host state must be significant. Such contribution is expected to be made to the host state as opposed more generally to the economy of the host state. And what should qualify, what would mean significant? The panel would note that in joint mining, the sum of 9.6 million sterling was not regarded as a contribution to the economy of Egypt. While it is not submitted that tribunal should set fixed monetary thresholds, it cannot be that any contract that injects any amount in the GDP of an economy suffices to be an investment. In our case, although the respondent do not contest that the claimant provided employment to the Malaysian national, this benefit is not on the same quality or quantity as envisaged by the ICSID jurisprudence. Mr.
Bowman, sorry.
Yes.
If I can just ask a question and to take you back to the second point that you made about the intention of the parties. If the subject matter of the contract results in significant economic development to the whole state, irrespective of what the parties had intended, is the party's intention relevant?
The party's intention is relevant as per the Salini criteria to qualify as whether there was a contribution to the economic development. The intention of the parties, and this is a doctrine because the claimant cited the Professor Schroe. This is a doctrine that the intention of the parties when concluding the contract needs to be aware and to intend to contribute to the economic development of a host state.
But on my reading of the Salini decisions and the four factors emanating from that decision, nowhere is intention indicated to form one of the factors or to supplement any of the other four factors. And I understand Professor Schroe's position, but objectively, if the investment does result in significant economic contribution, if both of the parties or one of them did not intend it to be so, does it really matter?
I would take the view that it matters. It matters because all these conditions would need to be taken holistically and not individually. When I'm analyzing the contribution made to the economic development of Malaysia, I need also to analyze the obligations under the salvage contract, but also the intention of the parties when they were entering into the salvage contract.
Okay, thank you.
Thank you. Mr. the Arbitrators, I will finish by simply indicating that for all these reasons, and in absence of such an effect to the economy of Malaysia, the salvage contract can only be interpreted as an ordinary commercial contract and cannot be construed as an investment within the meaning of Article 25, Subsection 1 of the ICSID Convention. I will now pass the floor, assuming that the arbitrators have no further questions. I will now pass the floor to Mrs. Cara van der Pol.
Thank you, Mr. Bowman.
Thank you.
Good morning, Mr. Arbitrators, Madam Secretary, and colleagues. My task is to address you on the risk elements of the Salini criteria, and in doing so, I intend to examine the relevant terms of the salvage contract before considering the decisions that have been handed down on this leg of Salini, and then their application to the present facts. So on the terms, you will have noted that the parties' memorials paraphrase the contents of the salvage contract but closer scrutiny of the precise terms is going to be required. For a start, the preamble provides that the contract was to survey, identify, classify, research, restore, preserve, appraise, market, sell, auction, and carry out a significant survey and salvage. Having defined the works, the preamble records that they were for the sole purpose of archaeological interest and the study of historical heritage. Clause 2 is significant. 2.2 provides that the contract shall be on a no fines, no pay basis, and all expenses incurred shall be on the accounts of the salvor. Clause 4 is, I think, significantly titled service fee, and 4.1 provides, in consideration of the work done by the salvor, the government shall pay the salvor a fee equivalent to the following. And then what follows is a particular calculation mechanism for fines with a value of a certain amount. The salvor would be entitled to claim a certain share of those proceeds. So we submit that the terms of the salvage contract and the no fines, no pay basis will not be entirely foreign to members of the tribunal. In the language of the Joy Mining decision, these are, and I quote, entirely normal commercial terms. And in fact, that the salvage contract is a commercial contract between the government and the salvor has even been admitted by the claimant. And I refer to the letter that is Exhibit P in the claimant's memorial. In fact, not only is a no fines, no pay basis of the salvage contracts common, but the contours of a salvage contract is effectively set in international practice. And here I refer you to the International Contract on Salvage, which was concluded in London in 1989. Article 12 states, conditions for reward, salvage operations which have had useful results give rise to a reward. Except as otherwise provided, no payment is due under this convention if the salvage operations have had no useful results. And then Article 13 goes on to deal with the criteria for fixing the reward. Now, we're not suggesting that this convention applies directly to this matter, but what it does do is set out the contours of what a salvage contract is. So this is a problem for the claimant we submit. It means that every salvage contract where the state is a counterparty, and I think the tribunal would appreciate that the nature of salvage means that this would frequently be the case, all things being equal, would qualify as an investment under the convention and thus warrant a hearing in this forum, regardless of the dispute resolution mechanisms that have already been agreed by the parties, as my colleague Ayanda has already pointed out. In any event, the claimant's approach is not only to allege that it did in fact assume all risk, but rather to emphasize that, that it did in fact assume risk, but to emphasize that it assumed all risk, in a way as to suggest that the magnitude of this undertaking might compensate for other deficits, and to elevate what would otherwise be an unremarkable commercial agreement between any two parties into something quite different and special and worthy of the attention of this specialist forum. So that requires a number of the claimant's premises to be tested. First, did the claimant in fact carry out all of the operational risks? Is it correct that in ordinary agreements, whatever those are, risks are assumed by both parties? And in fact, if the claimant did assume all of those risks, would this suffice to distinguish the salvage contract from an ordinary commercial agreement? So having planted those questions, I want to briefly mention the decisions that are relevant to the question of risk, a few of them which have already been mentioned by my colleagues. Okay, I'm going to start with Joy Mining. We've already dealt with that with a bit of detail. But here the tribunal found that it was dealing with the normal sales contracts on entirely normal commercial terms and said, risk there may be indeed, but this is not different from that involving any commercial contract. And in doing so, it distinguished between commercial risk and operational risk, which characterizes investments, and cautioned against a failure to draw a distinction between these two. And the results of that failure would be that any sales or procurement contracts involving a state would qualify as an investment. So the significance of this can't be underestimated, because the Joy Mining Tribunal was also alive to what I think is the quintessential or qualitative difference between these two categories of disputes. So if I may describe them somewhat colloquially, they are first, common or garden disputes where a state needing to secure certain goods or services happens to be a party to a commercial contract. And second, there are those disputes where there is a sovereign quality to the dispute. And for an archetypal example, you might imagine foreign direct investment into a long-term infrastructure project that the host state unexpectedly decides to nationalize to the detriment of the investing entity that would have probably assessed its risk and the prospects of recovering its real investment against the formal arrangements with the state as per the bilateral investment treaty. So,
Ms. van der Poel, if I may, you indicated earlier in your submissions that in most of these salvage contracts, the state is the contracting party. Does that not indicate that it is exercising its power as a sovereign in relation, to shipwrecks which are on its territory as a state? Would that not indicate that it's exercising that power as opposed to just as a normal contracting party?
Mr. Arbitrator, what I intended to convey was that the salvage contracts are often concluded with the state, not necessarily in the main. I'm not making those submissions as an maritime lawyer, but the issue is it depends on what sort of capacity the state is acting. So in a situation where there is a dispute about the terms of the agreement and the performance rendered by the salvor, that would be, in my view, a normal commercial dispute. If the state, for example, has acted to amend the legislation, appropriate the salvor's I suppose assets or otherwise interfered in its capacity as a sovereign in the contract, then that would be a dispute that would properly or possibly fall under the jurisdiction of this forum.
Okay, thank you for that answer.
Okay, so I was, if I may continue from there and embellish, I think on that point. Joy Mining also said that there would be no difference between the many state contracts that are submitted every day to international arbitration in connection with contractual performance as such bodies as the International Chamber of Commerce and the London Court of Arbitration. I'm aware of that I'm of time. So just to wrap up, I want to just refer briefly to Nova Scotia Power, which didn't concern a salvage contract, but the tribunal held that the matter before it did not constitute an investment because what was required for an investment is a risk that is distinguishable from the type of risk that arises in ordinary commercial transactions. In Romac versus Uzbekistan, which is not an exit decision, but in that matter, the forum had to grapple with what an investment was under Article 25, held that all economic activity constitutes a certain degree of risk, but that was pure commercial counterparty risk. Finally, I just want to refer the tribunal to one last decision. It's Raymond Charles Eyre and another versus the Democratic Socialist Republic of Sri Lanka. Here, Sri Lanka alleged that there had been no investments, and as the claimants undertook only pre-investment aspirational activity. And the tribunal agreed, even if the claimants were correct that the hotel project in question was potentially lucrative, that did not suffice. There needed to be substantive commitments and arrangements entered into involving specific commitments and financial costs, all of which would entail both certain risks as well as possible benefits. So given that the project remained at best aspirational at the time, the claimant's contributions rose only to the pre-investment level, and he did not face the operational risk necessary for the hotel project to qualify as a protected investment. So why that's relevant in this matter is that although the claimant did make an outlay, and we accept that, that outlay is properly characterized as the one in Raymond Ayres versus Sri Lanka. Because in that matter, like here, the claimant incurred no definite financial obligations. At best, there was an initial outlay that was analogous to anticipatory aspirational pre-investment activity. The claimant here could determine the scope and extent and indeed the duration of its exercise. It was not obliged to make any particular outlay, but it did so on anticipation of possible returns. Those are my submissions. Thank you.
Thank you, Ms. van der Poel. Is there still another member of the respondents team?
Yes, there is. I would like to hand over to Gugu Tom.
Thank you.
Presiding arbitrators, members of the tribunal, a very good morning. Today, my task is to speak on the duration of the salvage contract, indicating that the salvage contract is commercial in nature. In the course of my argument, I will make reference to various case law to prove why the duration of the contract makes it a commercial contract in nature. Arbitrators, sir, we understand that the claimant's position is that its contribution persisted for a sufficient period and that the minimum duration thought necessary in terms of Article 25, subsection 1 of the ICSID Convention from 2 to 5 years, and that the salvage contract persisted for 4 years, which places it within the purview of an investment contract under Article 25 of the ICSID Convention. Arbitrators, sir, the facts indicate that the works, as defined in the preamble, did take 4 years to complete. However, it must be noted that the salvage contract was intended for a period of only 18 months. To cast some area into the minds of the arbitrators, we now draw your attention to the timeline of how this ensued. In 1991, the salvage contract was executed. 1993, a variation order took place. 1994, the extension was concluded, and in 1995, an auction contract was concluded. Against this background and the submissions of my colleagues who have dealt with the terms of the salvage contract and the broader Salini criteria, I turn to briefly mention the decisions on this element. I would like to draw the arbitrators to the attention of the case of Alps Finance versus Slovak Republic. Here, the tribunal found that the requisite duration was not met because the underlying contract did not have, open quote, an ongoing duration, but rather exhausted its object and its purpose immediately, close quote. It recorded activities in Slovakia that are limited to a one-off transaction pursuant to a 4-page contract of an assignment, and thus it did not qualify under the duration description. Furthermore, in the Nova Scotia Power versus Venezuela, a contract for the supply of coal over the course of 4 years did not constitute an investment, as neither the contribution nor the risks were present. Similarly, arbitrators, sir, in the case of Tanneries versus Venezuela, it was held that a long-term offtake agreement for the sale of iron was not an investment, but was in instance a commercial contract in the respect of the purchase and the delivery at a known price. Now, the tribunal accepted Venezuela's submission that the offtake agreement is not an investment in its own right, nor does it consider that the offtake agreement would constitute an investment if a holistic approach were to be adopted. Despite the context in which it was concluded, it remained in essence, in accordance with the tribunal, a commercial agreement. Albeit to a decision in a different forum, if you look at the case of Romac versus Ubestan, it considered the Salini criteria and found that a contract for the sale of wheat over a 5-month period did not constitute an investment for various reasons. One of which was that the contract for the sale of up to 50 tons of wheat over a 5-month period did not constitute an investment. Now, the 5-month span of week deliveries under the contract did not satisfy what would be classified as duration requirement and was not sought normally associated with the term of investment according to the common understanding of the term. We would like to now draw the arbitrator's attention to the works which are defined in the preamble, which took 4 years to complete. But the essential element that we are raising at the respondent is that this was a single transaction. The claimant's performance was to salvage the cargo, prepare it for auction, and as the respondent, in turn, we were to pay the claimant for the proceeds. Now, various ICSID decisions have distinguished commercial transactions from investments based upon the duration each of it entails. However, in making the determination, the tribunals have considered the weight of authority that is regarding the duration as an element of an investment. Now, if we were to draw your attention, arbitrator sir, to the case of Ambiente Officio versus Argentina, it was held that there were some good reasons to leave a single transaction outside the concept of an investment. Now, the claimant's answer in its memorial was to reproduce the extract in full, that is, being that there are good reasons to leave a single commercial transaction, such as the delivery of a single load of cars outside the concept of an investment. But the claimant then seeks to introduce a distinction by averring that the salvage contract was far more sophisticated than the sort of transaction in the Ambiente Officio, which excluded the definition of an investment, insofar as it required a complex search and a salvage operation and a subsequent process of restoration of the cargo found on Diana. Given that these factors are to be considered on the facts of the case, MHA submits that the principle of Ambiente Officio does not apply to the tribunal. Lastly, we make reference to the case of Bavinda quoting Avocon, where the parties were involved in the construction of a highway, and the tribunal held that the jurisdiction, it held jurisdiction because such a project implies a substantial resources during a significant period of time. Arbitrator sir, various decisions have found that alleged investment did not qualify the term or the sufficient definition of a duration. And it's because it was never intended to involve a long-term allocation of resources. Now, if you take these facts that I've mentioned in the previous cases and what we are dealing with before this particular tribunal, you find that this transaction, which spanned over a period of 4 years, was considered a single transaction, and as such, it does not meet the criteria of a duration. Therefore, we argue before you arbitrators that the duration of the salvage contract indicates that the salvage contract is commercial in nature and should not be considered as an investment. I will now hand over to my colleague Ayanda Kambinde to do the closing remarks. Thank you.
Thank you, Ms. Tom. Before you hand over to Mr. Nkabinde, so in relation to this contract, it was initially for 18 months, and then it was extended. I'm not sure for how long, but eventually it took the parties 4 years. So if, for example, it had been extended to a period to cover 40 years, would that make any difference to your argument, or you still think that the subject matter of the contract is what's relevant and not necessarily the period, or do I misunderstand your argument?
Thank you for the question, arbitrator. Our core crux of our argument is that we need to consider that this was a single transaction which has spanned over 4 years, which was initially intended to be 18 months. Now, if you look at the case laws that I've made reference to, they've also alluded to the point that even though it had spanned over 5 months period, it does not meet the criteria of a duration as alluded to under the term of an investment. So what we allude to before the arbitrators is that you need to consider the duration of the contract, what it was intended to, and whether or not it spanned for 40 years, 100 years, or to how many ever years that it spanned into. The crux of it is that it was a single transaction and it ought to have been carried out through a period of 18 months.
Okay. All right. Thank you, Ms. Tom.
Thank you, arbitrator.
Mr. Nkabinde?
Thank you, Mr. Arbitrator. I believe at this point, the respondent closes its case, and I'll be back in reply. So, yeah.
Thank you, Mr. Nkabinde. Mr. Dlamini, over to you and your team.
Thank you, Mr. Arbitrator. Mr. Arbitrator, as initially introduced, my name is Zawadi Dlamini. I appear on behalf of my colleagues, which you've already met as well. But for your convenience, Mr. Arbitrators, the way in which we will structure our submissions to you is as follows. I will begin with addressing you first. Mr. Mohammed will be second, followed by Ms. Tabiseng Selepe, and lastly, Mr. Barkley Odihambo will address you. We anticipate that it will take approximately 10 minutes with our respective submissions, of course, depending on any questions we have. And really at this juncture, Mr. Arbitrators, I'm happy to proceed in addressing you with your permission.
Yes, please. Thank you. And thank you for that outline.
Thank you. Mr. Arbitrators, the matter before you is simple. You must determine whether the salvage contract entered between the claimant and the respondent is an investment. Now, I won't deal extensively with the facts of this matter as they've already been articulated by the respondents, and the parties have already exchanged comprehensive memorials addressing the statements, addressing the facts that are of common cause. But what you will find, Mr. Arbitrators, is that this matter doesn't turn into the facts, but rather the interpretation of legal principles. Now, it is common cause between the parties that in order for this salvage contract to be an investment, it must be envisaged as such in terms of the bilateral treaty agreement entered between Malaysia and the United Kingdom. And it must also be envisaged as such in terms of the ICID Convention, specifically Article 25, subsection 1. Now, it is also common cause that in terms of the bilateral treaty agreement, this salvage contract is an investment. So really, Mr. Arbitrators, what is before you and the issue that you must determine is whether the contract is an investment in terms of the ICID Convention. The problem that we have, Mr. Arbitrators, is that Article 25 does not expressly define what an investment is. In fact, on the reading of the article, it's not clear whether this salvage contract is an investment. Our submission is this. In such scenarios where treaties are ambiguous or are uncertain, there are principles available to this tribunal in resolving this ambiguity. We refer to the rules of interpreting treaties as codified in Article 31 and 32 of the Vienna Convention. And naturally, Mr. Arbitrators, the Vienna Convention finds application and is of relevance in the circumstances because both Malaysia and the United Kingdom have ratified it, but most importantly, the rules of interpreting treaties has been recognized by the international community, including the International Court of Justice, as expressive, not only of treaty commitment, but of also customary international law. Put differently, the rules of interpreting treaties is recognized by the international community despite parties having ratified the Vienna Convention or not. So if we look at the rules of interpreting treaties, Mr. Arbitrators, we will find that the first thing that we need to do is prescribe the ordinary meaning to investment. We must also determine the purpose and objects of the ICID Convention. And thirdly, as a supplementary measure, we must consider the preparatory works of the ICID Convention and look at the circumstances of the conclusion of the ICID Convention. Naturally, this third requirement, Mr. Arbitrators, would involve an analysis into the intention of the drafters of the ICID Convention. So that's the first principle before you, which is interpreting the ICID Convention. The second principle available to you is an analysis into the jurisprudence. It is common cause, as stated by the respondent, that the leading case in this matter, Mr. Arbitrators, is that of Salini v. Kingdom of Morocco. And you would have noted that there have been subsequent judgments which have cited Salini as establishing hallmarks that, if present, are indicative to an investment. In short, the factors are, number one, there must be a contribution made by the claimant towards a salvage contract. Number two, the salvage contract must operate for a specific period of time a duration of time. Number 3, we must determine the risks that were borne by the claimant. And number 4, we must determine whether the salvage contract contributed to the economic development of the host state. And the host state in this circumstance, Mr. Arbitrator, is of course Malaysia. Now, if we consider these two principles being the interpretation of the ICID Convention and the jurisprudence available to you, Mr. Arbitrators, our submission is simple. We submit that the hallmarks in Seleni, the characteristics that have been provided in Seleni, have been satisfied by the claimant. We submit that the test has been made, and my colleagues will later elaborate on the facts that support this contention, but in short, Mr. Arbitrators, we submit that, number 1, there has been a contribution made by the claimant in respect to the salvage contract. Number 2, the contract has operated for a duration in excess of the minimum time specified in Seleni. Number 3, all the risk was borne by the claimant. And fourthly, the salvage contract itself and the effects thereof contributed to the economic development of Malaysia. In the circumstances, Mr. Arbitrators, and contrary with respect to the respondent submissions, the claimant has satisfied Seleni. Alternatively, to the extent that you don't accept our argument, and to the extent that you find that one or more of the hallmarks in Seleni have not been satisfied, we submit that the test in Seleni should be interpreted flexibly, right? And this would be in line with judgments that have been handed down by this tribunal in the form of Bywater v. Tanzania and Philip Morris v. the Republic of Uruguay. Mr. Arbitrators, we submit that a flexible interpretation would be consistent with the preparatory work of the ICID Convention. It would be consistent with the intention of the drafters of the ICID Convention, and it would also be consistent with the objects and purpose of the ICID Convention. Now, when we look at the intention of the drafters of the ICID Convention, Mr. Arbitrators, we need to ask ourselves an important question. And the question we need to ask ourselves is, why was the definition of investment omitted from the convention? And the only conclusion and natural inference that one can arrive at is that the definition was intentionally omitted with the view that it would be interpreted broadly in line with the facts of any given matter, and also the intentions of the parties, which would be reflected in a bilateral or multilateral treaty agreement. Contrary to the respondent's submissions, respectfully, Mr. Arbitrators, this would not open the proverbial floodgates, because contracts or projects would still have to be subject to the criteria in Seleni, and ordinary commercial contracts would fall way short of investment if they don't satisfy any of the requirements in Seleni, and it can be shown that the parties did not intend for it to be an investment. Having said that, Mr. Arbitrators, and to the extent that I cannot be of any assistance to this tribunal, I will now hand over to my colleague, Mr. Suhail Mohammed. And what Mr. Mohammed will do is he will discuss Seleni, but he will specifically address 2 of the hallmarks in Seleni, being the contribution made by the claimant towards the salvage contract. He will also discuss the contribution made to the development, the economic development of Malaysia. And he will show that on the facts, the claimant has satisfied both these hallmarks. Thank you, Mr. Arbitrators.
Thanks, Mr. Kamini. Perhaps before you hand over to Mr. Mohammed, you've mentioned that the drafters of the ICSID Convention left the meaning of an investment open, but various other tribunals have applied the Seleni test and have followed it, which the drafters of the ICSID Convention could have done, but they decided to leave that open. So in light of your submission that the meaning of an investment must be left to tribunals, and your earlier submission, which I understand to mean that we should apply the Seleni test, but on your submissions, the claimant meets those requirements. So I just want to understand, what is your submission on the relationship between Article 25.1 and the Salini test, in light of your submission that that is a matter that is left open for tribunals?
Thank you, Mr. Arbitrators. The submission is this. Article 25.1 doesn't define an investment. And there's a reason why it doesn't define investment, because the drafters did not want to restrict the interpretation. And of course, you never know what can happen in the future. And essentially what they wanted to do is for the facts of any given matter and the intention of the parties to be considered in arriving at this definition. The problem about Salini, which I submit, we satisfy. But in the alternative, Mr. Arbitrator, the problem about Salini is that it doesn't take into consideration the intention of the parties, but it also doesn't take into consideration the objects and purpose of the ICID Convention. And as I stated, the intention of the ICID Convention is not to restrict parties in international investments and in international relations. And really, that is the perspective and view in which Article 25 must be viewed.
Okay, thank you, Mr. Zawadi.
Thank you, Mr. Arbitrator.
Mr. Mkiva, Dr. Kapinga, as pointed out, my name is Sahil Mohammed, and I will be addressing you today very briefly on two separate factors under the Salini test. That being the first factor, which I will refer to as factor 1, just for ease of reference, being whether or not the claimant, or MHS, as I might refer to them during the course of the submission, contributed to the project, contributed to the salvage contract. That is the first factor. The second factor, which is entirely separate from that, is that, and which I will call factor 2, is whether through the instrumentality of this agreement, of the salvage contract, there was some sort of contribution to Malaysia's economic development. Now, the reason I draw this distinction so clearly is because our learned friends for the respondent seems to have blurred the lines. And I think that becomes most evident from my learned friend Mr. Bob's references to our paragraph 12 as authority for our position, that we think that authority for the position that we try to extend the second factor. In actual fact, we deal with the economic development portion in paragraph 20 of our written memorials. Paragraphs 12 onwards deals with the first factor, which is about whether or not we contributed to the project. And so I'm going to start on that point. This tribunal's decision in Lesi Penta versus Algeria explained the content of this first factor. And what it is this. It simply considers whether a claimant or an investor, in this case MHS, has contributed its resources or allocated its resources to the execution of a particular project or a particular agreement or a particular investment, as we say is the case here. That's what this determines. Simply, the inquiry under factor 1 is whether the claimant has skin in the game. It doesn't speak to whether that contribution was made to Malaysia or its economic development or the advancement of its economy. That's dealt with under factor 4. It's a separate inquiry. In Binder versus Pakistan at paragraphs 132, this tribunal explained that contribution for the purposes of factor 1 goes beyond an injection of capital by the investor into the project. It speaks to not only capital, but whether the investor has employed people, whether it has trained people, whether it has expended its know-how and its special expertise in executing on the agreement. It is common cause in this case, and if I guide you to paragraph 2.4.1 of the Common Cause Statement of Facts, that the claimant has done all of that. The respondents don't deny it. They accept it even in their oral submissions. We had to expend the significant financial resources required for the search, the salvage, the extraction, and the auctioning of these of the Diana and its cargo. They admit that we have trained various Malaysian nationals and employed Malaysian nationals over the course of the 4-year period in which this was done. That is a contribution to the project. That, in fact, we bore all the contribution to the project. The respondent's only contribution was granting us a license to do so. And so, if you are with me on this point, that factor 1 considers whether or not a claimant has, or an investor has contributed to the execution of the agreement, as supported by the decisions in Lesi Penta and Bayingo, then on the common course facts of this case, you must be with me on the fact that the claimant has satisfied this factor in this case. The respondents can put up nothing to object to that, which is why you will notice, Mr. Arbitrator, that was not dealt with in their heads of argument, nor was it dealt with in oral argument. And so that point falls squarely on the side of the claimant. The second factor that I deal with, being the factor regarding economic development, is slightly more nuanced. The requirement there is that through the instrumentality of the agreement, through the instrumentality of the investment, did the claimant, MHS, contribute to Malaysia's economic development? Now, the respondents put up 3 arguments. The first is an argument of, well, and I just need to point out, this differs materially from their written submissions, where they at some point say, and this is at paragraph 4.3 of their heads of argument, that we make no contribution at all to Malaysia's economic development. That is countenanced by what they've said in oral argument, and I pointed out as follows. Firstly, they don't dispute that, firstly, they received a minimum of $400,000 worth of cargo that was taken off the Diana. That can be seen at paragraph 2.6 and 2.7 of the Common Course Statement of Facts. That as a result of the agreement, or as a result of the salvage contract, Malaysia netted not 1, but 2 rare vessels, that being the Diana and the Kapal Sultan, as well as all the cargoes on board. And they don't dispute that after these cargoes were auctioned off, Malaysia netted a profit. Those proceeds.
Mr. Mohammed, sorry.
Yes.
The recovery of the Kapal Sultan, is that relevant at all in what we have to consider as the tribunal? Because that was not part of your contractual obligations, and as I understand it, you came across it by accident. But is that something that should be relevant at all in our considerations?
We submit that it is. It was uncovered during the course of our salvage operations. However, even if we were to exclude it from this list, I don't think it changes the point. So we submit that it is, because it was during the course of our project, our contract, that it was found, and it was found with our resources, and it contributed $942,000 to the Malaysian public purse. So we submit it was, but if the panel is not with me on that score and believe it's extraneous, we do not think it detracts from the point that I'm going to make on contribution.
Thank you.
Perfect. So on those 3 factors, it's clear that it's not that there was no contribution that was made. Malaysia got something out of this, economically, that is. When I say economically, I mean funds or assets to the public purse. Their issue with it is significance, size. They say no. It was not significant enough compared to Salini, compared to the highway project in Salini, or compared to the Suez Canal in Joy Mining. They say this was small fry. I refer you to the judgment of Czechoslovakia Bank, which the respondents did raise regarding banking regulations. And in that judgment, in that decision, this tribunal explained that there is no minimum threshold, or no fixed minimum threshold, that needs to be considered when it in respect of economic contribution, or financial contribution to economic development. And this makes sense in the overall scheme of the exit convention, because, and my learned friend, Mr. Odhiambo will take you through this shortly. At the inception of the convention, there was debate on whether a monetary limit, and this time a very low monetary limit of only $100,000, ought to be inputted into the definition as a threshold, the bottom threshold for an investment. And the answer was no. And that was because it was found, and Professor Schroyer says this in his book, the 2009 version of the commentary, not the 2001 version, that rules out important test cases, which may have made some sort of other contribution, but because of the small monetary amount, would be ruled out, and thus depriving parties of being able to seek recourse before this tribunal. And so on that front, we say the size of our investment, our financial investment, does not matter. The fact that it was there is all that counts. The second point that our learned friends make is that we never intended for this to contribute to the development of Malaysia. And I'm with you, Mr. Arbitrator, on the point that that is irrelevant. There is no authority.
Sorry, Mr. Mohammed, I have not taken any position in relation to that question. That was just a question to Mr. Bab to make sure I understand his submission. Whilst I am talking, Mr. Mohammed, I just also wanted to ask you, so if I'm understanding your submission correctly, you argue that you have met the requirements of the Salini decision, but in the alternative, you also argue that it should be modified. Now, on my reading of the Salini criteria, they don't include an aspect about significant contribution, but the respondent does. So I just want to understand, do you say that in terms of Salini, you have met that criteria and significance is not a requirement at all? And that is something that on your version, we should not consider?
Firstly, forgive me for my liberties in respect of the first submission. But on the second one, I think that accurately captures the point. In respect of the fourth factor, that is, we submit that the size of the financial outlay or the financial economic development is neither here nor there. What must be considered is whether there was or was not. And the question of significance sort of raises a prickly issue, because what it does is, what it potentially does is excludes important investments from the ambit of this convention. And that was not the intention of the drafters when putting together this convention. But if you are not with me on that point, then we submit that our contribution was substantial. And I point out for this reason. Professor Schroyer draws on the judgment or the decision of this tribunal in Mitchell versus Congo, which, as you know, related to the services of a law firm whereby the profits were sent back to the United States. And he explains that, and I'm going to use his words directly, if you'd allow that, it's that economic development should not be restricted to measurable contributions to GDP, but should include the development of human potential, political and social development, and the protection of the local and global environment. Now, this fits squarely within the purpose of economic development, because in a complex, sophisticated economic climate such as the one we operate in, it would be, I think, insufficient to suggest that only a contribution in assets or a contribution sounding in money is a driver of economic development. We submit that during the course of our expedition, our agreement, we trained various Malaysian citizens, we employed them, and we taught them certain skills relating to salvage and restoration. The respondents make common cause with this in paragraph 2.5 of the common cause facts. In addition to this, once we hoisted that out of the sea and those Rare porcelain pieces were found, brought out after 2 centuries under the water. They were not just only sold in Amsterdam to rich collectors. $400,000 worth of these items were taken by Malaysia, and they were put in their national museums for public consumption. This does many things. Firstly, it enhances Malaysia's cultural tapestry. Rare items that are now a specific part of their history are no longer submerged under the ocean, but are sitting on mantles in public museums for public consumption. That is of interest to Malaysian locals, as well as a driver of tourism. That's a social contribution. The fact that people were trained and now have developed new skills in a sort of very niche area of practice, that's a human development. Those are all drivers for, yes, Mr. Arbitrator.
Mr. Mohammed, firstly, just keep in mind time. And the second question, well, my question is, do you know whether it has in fact resulted in a tourism boom for Malaysia, having those artifacts in the museum or having trained people? Has it actually manifested in any significant, economic benefit to Malaysia?
Mr. Arbitrator, I'm concerned about the use of the word significant, but I will let it go as just being a question. But no, I cannot give you facts on whether or not, or give you quantitative facts on that answer. And the reason for that is because it's currently just unknown and ongoing. These pieces, as we sit and argue here today, are sitting in a museum in Malaysia. We don't know how many eyes are on it. We just know that it could be. And we submit that is enough for the purpose of development. And so, with that being said, and on those 3 points, firstly, that we have made an economic contribution and that the amount in question is not relevant in terms of Article 25. And that secondly, our contribution extended beyond that financial contribution to something more cultural and social and political. We submit that we also meet this 4th requirement of the Salini test, that being factor 2 in my submissions. Now, I know I'm very short on time, but I need to make one very short submission, Mr. Arbitrators, if you will let me. And that's that if you are not with me, that on the fact that we have completely, not or partially fulfilled factor 2, the economic contribution point, I don't think you can be with me on the fact that there was 0 contribution. If it goes to the question of significance or partial fulfillment, then this submission is relevant. Then we submit that on the strength of Maffezini versus Spain in multi-factored tests in international law, they should operate on a sliding scale manner. What that means is that a weakness, not an absence, a weakness in respect of one factor should be countenanced by a strong showing in respect of the other 3. That is analogous, Mr. Mkiva, because we are fortunate to share jurisdiction, to the common law principles on interim interdicts in the South African civil procedure, where a weak showing on a prima facie right may be countenanced by a strong showing on a balance of convenience. That same concept should apply here. And in this case, where I have shown we have uncontroversially and I think unopposedly met the first factor, and where my learned friend, Ms. Selepe, who will address you shortly, will show you that we come home on both duration and risk, our partial fulfillment on the economic development contribution should not be fatal to our fulfillment of the general Salini test, on the basis that on a sliding scale and on balance, we fulfill the test. And with that, Mr. Arbitrators, I end my submission unless you have any further questions for me.
Thank you, Mr. Mohammed. No further questions from me.
Thank you, Mr. Arbitrators.
So my apologies. I'd like to address a small query. It can be responded to by either of you 2 gentlemen, Lamini and Mr. Mohammed. You have relied on Bywater versus Tanzania. And my understanding of that case, they used the BIT, the Bilateral Investment Treaty, to guide interpretation of the convention, of that ICSID convention. And what they ended up doing was to broaden the scope of exit jurisdiction. And I know, I'm sure you have looked at the case of Phoenix against the Czech Republic, where the tribunal there said that the jurisdictional requirements under exit were separate and could be in addition to other jurisdictional requirements under the BAT or any other agreement. Now, Phoenix, and I need your view there, how that fits in your submission. Phoenix did say that a BAT can confirm or even restrict the exit notion, for example, of an investment in the BATs, but they cannot expand it in order to access arbitration under the exit convention. Did you give thought to Phoenix?
Mr. Kapinga, if I may.
Yes,
I'm not so learned as my friend, Mr. Odiambo, who will address you on that very complex point of law. But what I can submit is this, is that firstly, the argument we make in respect of the flexible test under Selene, or the expanded test under Selene, if you will, is an argument we make plainly in the alternative. At the outset, we say that we meet Selene, and it's only if you are not with us on that we traverse that other option. On your question regarding Phoenix, whether or not the bilateral treaty expands the definition of or the interpretation of Article 25, we submit that is not our submission, at least as far as we understand it currently. We don't seek to expand the interpretation of Selene or make it more flexible with reference to the BIT. That issue has been resolved, and it's common cause that this is an investment in terms of that. Our expansion of the test of the Selene requirements is dealt with specifically under the framework of Article 25(1), looking at the travaux preparatoires and various other decisions made by this tribunal. So we don't intend to mix those waters, as it were, if that answers your question, Dr. Kapinga.
Yeah, you have addressed the point, but I probably hope to hear more from the learned Dr. Odiambo on the point. Thank you.
Thank you, Doctor.
Mr. Odiambo, I think it's over to you. And as you can tell, I mean, we're waiting in anticipation now.
Mr. Arbitrator, I hate to be the bearer of bad news, but before the much anticipated Barclay, I would like to address the tribunal on the remaining hallmarks, as it were, of the Selene case.
Thank you, Ms. Selepe, and my apologies.
It's fine, Mr. Arbitrator. As stated by my learned colleague, Mr. Suhail Mohammed, I am Tabiseng Selepe, and I will be addressing the tribunal on the remaining hallmark elements as outlined in Selene, that being of duration and risk. I will begin by addressing the element known as risk. Now, Mr. Arbitrators, it is common cause, as shown in our common cause state of facts, that the risk was borne by the claimant in totality. Now, when we place reliance on cases like Selene, we are then also traversed to cases like Benda, where it's been outlined in both cases that when it comes to the element of risk, especially when we are talking in the context of operational risk, such risk must be shared by both parties. Now, as I've indicated earlier, it is common cause that this risk was borne by the claimants alone. What the respondents then submit in this regard is that they attempt to show a distinction between commercial risk versus the investment risk. And I believe my learned colleague, Ms. van der Poel, placed reliance on the International Convention on Salvage of 1989. I submit respectfully, Mr. Arbitrators, that this particular convention is not applicable in our case. I refer to Article 6 of this particular convention, which provides that the contract implies, it applies that the convention will not apply if it is implied otherwise by the contract. When we look at the particularity of our contract, we see that there is no such implication there. This is because our contract specifically outlines what the obligations are that are expected of the claimant. This included the salvation of the wreckage, the restoration, inventory, taking photographs, cleaning, storage, safekeeping, and insurance of the salvaged artifacts and items. When we look at Article 13 of this particular convention, which was referred to by my learned colleague, Ms. van der Poel, Article 13 then goes on to outline what are the rewards that a claimant, or rather a salvager, can expect when outlining or performing such contracts. Now, Mr. Arbitrators, I submit to the tribunal that this criteria for fixing the award as contained in this international treaty does not accord with what was the fixed reward in terms of the contract. And therefore, by implication thereon, this convention cannot be relied on. And I submit that it should not be relied on by this tribunal, as it is not what the parties intended. In fact, it is not applicable at all to the facts of our case.
Sorry, Ms. Lepper, I understood Ms. van der Poel's submission in relation to this convention to not be that it is applicable in this instance, but she was using it to show what ordinarily happens in a salvage contract such as the one that we have. So she wasn't calling on the tribunal to apply this convention, but just sought to show us what would ordinarily happen. Do you have a different understanding of her submission?
Thank you for the question, Mr. Arbitrator. I think in that respect, I may have a different interpretation of what was posed by the respondent than you do. But to answer your question, even if it were on that interpretation as you understood it to be, I still submit, and with respect, that what the purpose of referring to this convention is to place difference, ensure difference, or rather to imply what is the ordinary risks that are borne in such commercial contracts, such as these of salvage. But the point that I'm trying to drive home is that our contract and the agreement that existed between the parties went far beyond this and was far more sophisticated than what is found in normal or ordinary commercial contracts of this like. And again, I go out to outline the particular requirements that were expected of the claimant, such as the restoration of the artifacts, the inventory of the artifacts, the storage, the cleaning, and also the auctioning. So what I hope to submit and to drive home to the tribunal is that, notwithstanding that this international convention outlines what is found in ordinary commercial contracts, on the facts of our case, we are not dealing with an ordinary commercial transaction or contract in terms of this convention. Instead, this was a more sophisticated transaction which was envisaged and intended by the parties.
Thank you for that clarification, Ms. Lepe.
Thank you, Mr. Arbitrator. I would then like to move on to the final requirement, which is encompassed in the Salini test, and that is of duration. Now, just as a cursory preliminary point, Salini goes and outlines that a contract must subsist for a certain duration of time. And it then goes on to set this minimum requirement of 2 to 5 years. I submit with respect, Mr. Arbitrators, that as this tribunal has noted time and time again, we are not bound by the decisions made by earlier tribunals. Rather, in other words, there is no principle of stare decisis in the tribunal. So while we may apply and refer to Salini, we must not fall into the trap of restricting ourselves overly to what has been set out in Salini. And the reason I bring this up is what is a common cause fact in our matter is that this contract subsisted for a period of 4 years. This was by mutual agreement between the parties. My learned colleague, Ms. Tom, took us through a chronology of the issues and started and explained and took the tribunal through by reiterating that initially the contract was set for 18 months. I submit with respect to my opponents that this is inconsequential. What is important here is, as a matter of fact, the contract did in fact meet the requirements as set out in Salini, in that it lasted for 4 years. So whether or not the intention was for it to go for 18 months is inconsequential here. We are concerned with what is the factual basis of what we are looking at today. Again, on this point, our learned colleagues have pointed out that, our learned colleagues have pointed out with reliance on ambiente that there is good reason for single commercial transactions to be left out. And we can see that, yes, there is good reason, but that does not mean that every single commercial transaction should be left out of the ambit of what constitutes an investment. And particularly in this case, I submit with respect that this wasn't a simple commercial transaction or a single commercial transaction as envisaged in ambiente. Instead, and as I implied earlier, this was a far more sophisticated contract. And it actually, if we look at each of the obligations that were fulfilled by the claimant in this matter, it consisted of multiple transactions which had a general unity. And I placed reliance on the case of Holiday Inn versus Morocco in this respect. So we submit, Mr. Arbitrators, that even though the respondent has posed or has argued that we have only met the duration point in a qualitative sense, and also that it was a single transaction, we deny that this was only a single transaction, but that it consisted of the salvaging of it, the restoration, the auctioning. So there were multiple steps that had to be taken in order for this to see fruition. So I believe that on that note, if I have no more questions from Mr. Arbitrators, and I'm of no further assistance to the tribunal, I would like to hand over to the much anticipated Mr. Barclay Odiemo, who will take us through the flexibility, our alternative argument in using a flexible approach. I thank you, Mr. Arbitrators.
Thank you, Ms. Lepe. No further questions from me.
Good morning, Mr. Arbitrators. As previously indicated, my name is Barclay Odiemo and I appear as a co-counsel for the claimants. My submissions this morning will be with regards to a flexible interpretation of the Salini test. It's worth noting that I make these submissions in the alternative and without prejudice to our earlier arguments that indeed the claimant's investment cumulatively satisfies the Salini criteria. My submission is that to implore this tribunal to interpret the Salini test in a flexible manner, bear in mind that the Salini test merely sets out typical characteristics of an investment rather than strict jurisdictional requirements. I shall make my submissions in a three-pronged manner and based on the following limbs. That firstly, Article 25 of the ICSID Convention has no definition of the term investment. And secondly, that the preparatory works of the ICSID Convention points to a clear intention by both the drafters of the convention as well as the contracting states that the definition of investment would be left open. And lastly, and most importantly, that the Salini test, or the criteria developed in the seminal award of Salini, is not mandatory and is not expressly set out in the wording of the ICSID Convention. I'll begin by an exposition of the contents of Article 25 of the ICSID Convention that provides for situations where this tribunal may invoke its jurisdiction. Mr. Arbitrators, Article 25 of the ICSID Convention states that this tribunal would have jurisdiction in relation to legal disputes arising out of an investment that is entered into between a contracting party to the ICSID Convention and a national of a contracting seat to the ICSID Convention, provided that both have consented to submit such kind of disputes to the ICSID. We submit that the respondents in paragraph 3.2.2 of the memorials actually admit that Article 25 of the ICSID Convention does not provide a specific definition of investment, nor does it delimit or delineate what actually would amount to an investment. However, the respondents have sought to leapfrog and jump into an analysis or an exposition of ICSID jurisprudence with regards to what amounts to an investment within the meaning of Article 25. We submit, and as alluded to by my colleagues, that we would make recourse to Articles 31 and 32 of the Vienna Convention on Law of Treaties. Both articles have attained or have crystallized to customary international law with regards to interpretation of treaties. Article 31, which is a starting point in interpretation of treaties, is that it behooves or enjoins judicial bodies such as this to interpret the ordinary meaning of a term in a treaty in light of its object and purpose. We can agree, and it's a matter of common fact, that Article 25 of the ICSID Convention provides no ordinary meaning of the word investment. We provide that in the absence of this, we are forced to move to supplementary means of interpretation, which is Article 32 of the Vienna Convention of Law of Treaties. And Article 32 provides that we look at the supplementary means such as the preparatory works that were involved in the conclusion and negotiation of the treaty that's being interpreted. I submit that in this case, we need to look at the preparatory works of the ICSID Convention to understand the context or the understanding or the negotiations between the parties in arriving at the definition or the present day Article 25 of the ICSID Convention. We submit that initially, and I wouldn't want to bore you with a chronology of the negotiations that were involved, but initially there were drafts that were put forth on the current day Article 25 of the ICSID Convention that specifically delineated what would amount to an investment. As a matter of fact, the initial drafts provided a floor, a financial limit that claims that could be submitted to this tribunal would only be claims of $100,000 US. Additionally, it also set out that the duration that would be that an investment needed to take place would be not for a minimum of 5 years, would be for a minimum of period 5 years. We submit that although there were initial attempts to specifically delineate what an investment is, the prevailing view, and after serious negotiations, parties eventually decided to leave this definition open. The British proposal that leaving that restricting the interpretation or definition of investment would lead to jurisdictional difficulties was adopted by a majority of the states, who then settled at leaving the definition of investment open, so that this can then be decided through the consent of specific parties through a bilateral investment treaty. While we submit that, and we agree with the claimants, with the respondents, that the Salini test provides an objective criteria within which investments should be looked at. Our point the point at which we differ is that the respondents would like this tribunal to look at those criteria as strict jurisdictional requirements, such that in the absence of even one of these requirements, then it would be dispositive of the rest. On the other hand, we submit that this wasn't the intention. We submit that the Salini test merely provides guidelines or typical characteristics of an investment that are indicative of whether there is a presence of an investment or not. Consequently, even in the event that one of these criteria is missing, the tribunal should look at these criteria cumulatively and balance them out. And if the ways tilt towards most of these criteria being satisfied, should indeed find that there is the presence of an investment and that there is jurisdiction. We submit that further preparatory works with regards to Article 25 can be gleaned from the report of the executive directors of the World Bank in 1965. Excuse me, and make reference to paragraph 25 of their report dated 18th March 1965, in which they set out that parties deliberately decided that, one, there would be no specific definition of what an investment is. The parties decided to do away with a limit that a financial claim must satisfy in order to be submitted to the jurisdiction of this center. And thirdly, that those parties specifically decided to do away with the requirement that investment had to be undertaken for a period of at least 5 years. We submit that in the absence of such a restrictive or strict objective criteria of an investment in Article 25 of the Exit Convention, this tribunal ought not to apply the Salini test in a strict and a rigid manner. Indeed, we make reference to the case of Patekniki versus Albania, in which the Exit Tribunal found that even though the Salini Tribunal made a decent attempt to try and circumscribe the essential elements or characteristics of an investment, it is doubtful whether this can be used as strict jurisdictional requirements. As a matter of fact, the tribunal went on to hold that there is a clear trend in investment tribunals to hold that the Salini test is merely typical characteristics of an investment rather than strict jurisdictional requirements that have to be satisfied before this tribunal can invoke its jurisdiction. And we further make reference to other additional cases such as Philip Morris versus Uruguay, in which the tribunal also held that it is very doubtful whether the Salini test has any relevance to the interpretation of Article 25. It held that the 4 criteria that have been set out in the Salini test are merely typical characteristics that would guide a tribunal in finding whether there is a presence of an investment or not, rather than strict jurisdictional requirements that have to be applied cumulatively. Mr. Arbitrators, I'd also want to dissuade you from the notion that Philip Morris or Bywater are abnormalities. As a matter of fact, there have been other decisions that have warned against an overly strict interpretation of Salini versus Morocco. In this case, I make reference to the case of DEA Group versus Ukraine, as well as Abaclat versus Argentina, which both set out that there is a problem that would be created if tribunals apply an overly restrictive application to the Salini test. Both tribunals held that if the tribunal looks at the Salini test as limiting or creating a limit on investments, then this would go against the intention of the parties to leave a broad, a flexible definition under Article 25 of the ICSID Convention. We also further make reference to the much cited case of Bywater versus Tanzania, in which the tribunal also held that the Salini test is not a fixed and mandatory test, because it's nowhere within the ICSID Convention is it expressly mentioned, but it merely provides guidelines that are indicative of whether there is a presence of an investment or not. In the case of Philip Morris versus Uruguay, the tribunal also held that Salini test cannot be used constrictively to do away with the broad nature, to do away with the broad and flexible approach that has been developed in terms of the negotiations and conclusion of Article 25. And we submit that in trying to interpret the Salini test in a restrictive manner, we do away with the consent of the parties. Mr. Arbitrators, it is right that consent is the cornerstone of treaties. If the parties of the contracting states to the ICSID Convention intended that there would be a delimitation of what applies as an investment, nothing would have stopped them from explicitly expressing this within the wording of Article 25. As a matter of fact, it's commonplace that there were numerous attempts to try and delineate what would apply as an investment, and this was objected to by a majority of the contracting states. And by the tribunal applying an overly restrictive approach in this case would be to negate the consent of the contracting parties and the intentions of the drafters of the ICSID Convention.
Mr. Odiambo, sorry to disturb. I just want to ask. So the respondents have referred to the preamble of the ICSID Convention, and specifically that the convention was drawn up in light of the need for international cooperation for economic development. And I highlight economic development. And as I understand their submissions, they argue that even though the Article 25.1 of the ICSID Convention is silent on what an investment is, it should always be understood whatever an investment is, it should lead to economic development. In your submissions, do you accept that proposition?
We submit that not necessarily must it lead to, that should be one of the aspects that are looked at in terms of economic development. However, we submit that even in the absence of this test being satisfied on a quantitative aspect, the tribunal must also have regard to the other additional characteristics, in the sense that even if there is if the strength of one of the hallmarks, which is economic development, is somewhat lacking, this should not be dispositive automatically of each of the other hallmarks of an investment. Because to do so, we submit would do away with the object and purpose of the ICSID Convention, which is to lead to a settlement of disputes, of investment disputes. We submit that by looking at it in a constrictive or a restrictive manner, such that even in the absence of fulfillment of one criteria, everything else is automatically knocked out, and this tribunal declines jurisdiction, this will lead to the unintended consequences of an arbitrary exclusion of certain nature of contracts. And by doing so, this will be a negation of the intention and the object and purpose of the tribunal. So I agree, the long and short of it is that I agree that that is one of the elements. However, it should not be dispositive of all the other elements, hallmarks of an investment as set out in Salini versus Morocco. Mr. Arbitrator, do you have other questions for me?
Yes, I just want to ask, and this is just having regard to the fate of us poor arbitrators. Without Salini and the criteria in Salini, how do you suggest that arbitrators go about assessing what is an investment, independently of the criteria in Salini?
We submit that the arbitrators, one of the elements in which the arbitrators can look at this is by looking at the definition that the parties have adopted specifically in the bilateral investment treaties. We submit that Article 25(1) of the Exit Convention in itself sets an outer limit or an objective criteria of disputes that can be submitted. We submit that Article 25 as currently drafted has an objective limit in the sense that it sets the nature of disputes that can be submitted to this tribunal, as well as the nature of the parties. It does so by saying that any dispute that comes has to be a legal dispute arising out of an investment. That means that it should touch on legal rights and liabilities. And secondly, on the nature of parties, it deals with the fact that there has to be, the dispute has to arise from between a contracting party to the Exit Convention, as well as a national of a contracting party. So we submit that the bilateral investment treaty in itself can delineate what amounts to an investment. However, we also are cognizant of the fact that consent in the bilateral investment treaty itself does not mean that anything that parties agree to can come before this tribunal. And this points us back to our submissions that while we do not discount the Salini criteria, we very much agree with the Salini criteria. We submit it should not be applied as strict jurisdictional requirements because it has no mandatory force of law within the Exit Convention. And secondly, that applying it in a restrictive way actually negates the intention of the parties to deliberately leave it open. So we submit that a tribunal should carry out an empirical assessment of the facts and circumstances of the case brought before it within the broad parameters of Salini versus Republic and make an assessment whether most of these hallmarks are met. Does that answer your question?
Yes, it does. And perhaps if I can move on to another question. We did note that both parties in their memorials accept that the salvage contract meets the requirements of an investment under the BIT, but they don't explain why that is the case. Perhaps if you can explain from the perspective of the claimant why it accepts that there is an investment under the BIT, and if I could ask whoever is going to respond on behalf of the respondent, just to also cover that in their response.
Thank you, Mr. Arbitrator. Indeed, we submit that it meets the requirements of Section or Article 1 of the Bilateral Investment Treaty between the United Kingdom of Great Britain and Northern Ireland and the Republic of Malaysia. And this we submit because of the following. Article 1 of the Bilateral Investment Treaty provides that an investment includes a contract, which among others applies a contract which among others applies to a contract for a claim for money or performance of an obligation. We provide that in this case, the salvage contract indeed meets the requirements of a contract which provides for a claim for money and the performance of certain obligations. Because under the salvage contract, our clients, the claimant, had the obligation of obtaining or trying to retrieve the materials that were lost within the shipwreck of Diana and was supposed to offer them for auction. And there was an agreement between the respondent and the claimant on how payment would be made, depending on whether the claimant actually located the missing articles. And so we submit that there was a claim for money and there was a performance obligations in that the claimant had an obligation to perform the contractual obligations. And in the event that they were successful, there was money that was to be paid back to them by the respondents based on how much the sale or auction of these articles would fetch. Mr. Arbitrators, if there's no further questions for me, I will move to our conclusion, which is that firstly, we submit that in the totality of arguments that we have set forth as counsels for the claimant's investment meets or cumulatively satisfies the Salini test. And in the alternative, that this tribunal is not persuaded that we meet the requirements of the Salini test, that this tribunal ought to apply a flexible interpretation of the Salini test in a manner that's consistent with the contractual intention, with the intention of the contracting states. And under this flexible approach, we submit that the claimant's investment actually amounts to an investment within the meaning of Article 25(1) of the ICSID Convention. And our prayers is that we implore this tribunal to consequently find and hold that the claimant's investment actually satisfies the requirements of Article 25 and Article 1 of the Bilateral Investment Treaty as an investment, and that this tribunal has jurisdiction over this claim. If there are no further questions, we rest the claimant's case. Thank you.
Thank you, Mr. Odhiambo. Mr. Nkabinde.
Thank you, Mr. Mkiba. I assure you I am conscious of time, so I will do my best to be as brief but as effective as possible. I think perhaps the starting point is the claimant's characterization of our application of Salini. At paragraph 3.2.2 of the respondent submissions, we state, after we set out the Salini test, we state that these factors are interrelated and should be examined in their totality. Consequently, there is absolutely no submission that in the absence of one of the factors, the claimant ought to fail. Our case is, and always has been, that on a holistic interpretation or application of the Salini test, the salvage contract does not fall within the definition of an investment. So I'd just like to, from the outset, dispel that mischaracterization. Now, perhaps it's more relevant for me to go on to certain clashing points in respect of the Salini factors. So on the economic development factor, our learned colleagues pointed out, or rather the claimants pointed out, that firstly, because Malaysia had pocketed funds, and because there are people who have been trained in what Mr. Mohammed stated was a niche market. And then thirdly, because there was a tourism boom. Now, obviously on the third point, Mr. Mkiva, you pointed out that or in fact, the claimant conceded that there was no way to quantify any boom in tourism. In fact, in their papers, they describe it as some vague group of people who are interested in heritage and agriculture. And in submission, that simply is just not enough. But perhaps more to the point, they also place stock on the employment aspect, the fact that people were employed. But again, Mr. Mohammed himself points out that these people were trained in a very niche area. There is no evidence that that market has grown. There is no evidence that there is any further value for the salvage industry in Malaysia. And again, in respect of the fact that Malaysia had pocketed some funds under the contract, again, this goes back to our submission that it cannot be that simply because a state is party to a contract and receives some kind of performance under the contract, that automatically brings it within the definition of an investment. So that is not true. And that is why the respondent aligns itself with the approach taken in the Joy mining cases and the other cases that we have cited. Now, just to quickly dispense with the duration aspect and the risk, we were not properly engaged by the claimant on the point that the risk falls within the ordinary type of risks that arise in a salvage contract. And that's a point that they simply cannot succeed on, or in fact, a point on which they cannot overcome our challenge. And I think that's something that I could leave there. And then finally, Mr. Mkiba, just on the test, the duration aspect. Another aspect that the claimant cannot dispute is that this was one single commercial transaction. Now, whilst they point out that the transaction did persist for a period of 4 years, there were no reciprocal or continuous obligations. It was effectively, go salvage the ship, tell us when you are done, and we will pay you. That is not dissimilar to or rather in principle, it is not dissimilar to the contract as cited by, to the contract in the case cited by both parties being ambiente officio. But now I turn to the flexible approach, the alternative argument that has been advanced. Now, I must first point out that the claimants do refer to Bywater and Philip Morris in favor of a flexible approach. But in their written submissions, or rather, Philip Morris and Bywater, those cases are authority for the notion that the meaning of the word investment in the bilateral investment treaty can indeed be imported and be applied to the definition of the convention. Now, firstly, I must point out this was not a case that was made in the written submissions of the claimant. However, with that said, we firstly accept in this case that the salvage contract is indeed, or rather the salvage contract does indeed fall within the definition of an investment under the BIT. And we do not believe that that advances the claimant's firm, the claimant's claim to any extent. And the reason for that, in keeping in mind the principle in joy mining, being that commercial contracts must be kept distinct in order to maintain a stable legal order. BITs, by necessity, they must contemplate having to resolve a much wider array of disputes. BITs are in effect the forums or rather the dispute resolutions, the dispute resolution mechanisms in BITs are in effect the analogous to your lower court in a particular country. They deal with a wider array of disputes. And as you get higher in those dispute resolution mechanisms, there are more and more jurisdictional requirements that a party must meet. So it is not dissimilar to that concept. So necessarily, the definition in a BIT must be wider. But ICSID, and this takes us back to the point that perhaps is, that underlies all of this. The claimants accuse the respondents of applying an overly restrictive approach. Now, the difficulty with this is that, well, firstly, it's incorrect, but secondly, the claimants do not seem to take cognizance, as you pointed out in your question, of the actual purpose of, or the stated purpose of the convention. Instead, what was proposed, and I believe this was either by Mr. Dlamini or Mr. Odhiambo, what they propose is that the dispute, sorry, apologies, yes. What they propose is instead that thank you. What Mr. Odhiambo and Mr. Dlamini seem to propose is that this flexible approach or would rather do away with the factors identified in Salini, or instead water them down. But what they have said in particular is they have relied on the preparatory works, and they have gleaned an intention from the decision not to define an investment. Now, we accept that the reason that an investment is not defined is because we need to keep, or the tribunal must attempt to keep things flexible. But an investment must still have an objective outer limit. and it must operate in the four corners of the purpose of the center. And that outer limit, at very least, is contained, or rather, that outer limit is evident in the Salini test. And there's a reason that there is a long line of authorities that go with the Salini test, that apply the Salini test. So notwithstanding all of these cautions that are identified or made by various sittings of the tribunal, we accept those cautions. We accept those cautions to mean that we must operate within the four corners of the purpose. And respectfully, the claimant's approach in this regard would take us far beyond that. It would inundate the tribunal with claims from any contract to which any state agency is a party.
Thank you, Mr. Nkabinde. Can you hear me?
But secondly, oh man.
Yeah, you froze there for a minute, but I think you're back. Mr. Nkabinde, can you hear me? Okay. I think he froze there, but I think he was at the tail end of his closing remarks. Anyway, I did have one follow-up question for him, but I think it's not that material. So I think we can close the formal part of the proceedings with that. And perhaps Dr. Kapinga, and perhaps Dr. Kapinga, if we have any, if you have any sort of high-level feedback for the parties, perhaps we can do that now and indicate at a later stage which between the parties, in our view, we think ought to win the day based on the written submissions and the oral submissions made today. And we'll probably do that sometime next week, just after me and Dr. Kapinga have spoken to one another. But perhaps in the meantime, Dr. Kapinga, if you have any high-level feedback for the parties.
Well, this is not going to be easy. As you may realize, I was counsel for Tanzania in Bywater many years ago. And of course, we lost in that case in both respects, jurisdiction and on the merits. Yeah, so I was somewhat surprised that you'd rely on that case, given its rather constrained interpretation. Certainly, there was a sense there of the tribunal not wanting to let go. And this is not uncommon for tribunals to be very jealous of their jurisdiction. They don't want to hear that, hey, who are you? You can't listen to us. But anyway, I think that it's going to be a tough one. And as I was listening and looking at how the real case turned out, I thought if you guys had been there when it was being heard, would probably have a different kind of decision. And so we struggle in really giving credit to one group or the other, given our adversarial system. I think parties usually put in their best, and I've seen this in today's proceedings. And I also noticed that the parties were really thoroughly prepared in the manner in which they were presenting, in the timing of the presentation, and in the amount of authorities they looked at to support their cases. So maybe until we sit with the claimant in a room to try to make scores here and there, it seems to me that the performance day was almost on a draw if it was a football match. I have never seen such quality of presentations by counsel in an arbitration. When we were doing arbitrations a long time ago, they're not very popular, and and states always make mistakes. So when you represent them, it isn't an easy matter, and and some of the leading guys who you've been citing were involved in many respects with many of the earlier proceedings. And one thing I learned for African or lawyers for African governments in international settings, there was a sense, I don't know how I should explain it. It's like you're going to a foreign land and all you have is your bag. Okay, and the familiarity of the place matters, and that takes a toll on you. You go to a tribunal in The Hague. It's not an environment you used to practice, and you sit there for 2 weeks on a matter. You tend to lose your cut, but now, many years later, today, I was telling myself, if you guys that represented government, the government of Tanzania in the biowater matter, and many other arbitrations in which, in most cases, government was losing and continues to lose. I was getting a sense that maybe the lawyers, which I don't know if there's a league, there's a league amongst lawyers and arbitrators who tend to decide against African governments all the time. I'm not trying to take sides here, but it isn't that. It was preparedness. And I could tell from today's performance that it wasn't like what we used to do, because in many of those cases, state counsel were assisting government, and they certainly were not putting any commitment to the work. It was like their day job only. Unlike these days where you spend long hours of preparations, maybe there was no incentive. But what is unfortunate, and I don't know how we turn around that, in a place like Tanzania, they're now discouraging external counsel to support government. Unlike in the early 2000s, late 1990s, where private lawyers would represent government. Now they send the attorney generals and solicitor generals. And I can tell that's an issue, because the sort of attention you were paying to detail and to the arguments and to which case decided is a far call from what state counsel. I don't know about the South African state counsel, but the ones that I've had experience with only in December. In December last year, the Attorney General of Tanzania was representing the government in the English Commercial Court, High Court of Justice, Her Majesty's High Court of Justice, the Commercial Division. Because they could not pay for external counsel, they were allowed to defend themselves. Now imagine, that was the first time in an English justice I got. And with that kind of environment, I was not surprised that I was acting for the other side. This time I was not representing government because they said, we don't want you near us. I was with the other team, the investor team. Again, they lost. The same kind of problem I experienced with them continues today. So, and I don't know if this African thing, this cooperation, I don't know how we can get minds such as the ones I've seen today to play like a continental role in representing governments. I know there always have bad cases, but at least so that they're done in a manner which makes sense. So I think I'll probably give an A to both teams, but I'll have to speak to Claimant. I don't know, we might have to write different awards, I'm not sure, but that is something we'll discuss internally. So I congratulate all of you for just, that is a stellar performance. I'd say the preparedness was just extraordinary, and the way you addressed issues is something very, it makes me proud of continuing to be in practice. Sometimes you reach a point, you say, why am I doing lawyering? It doesn't feel good, but today it has really made me a lot younger. I feel like it should have been 2005 when we were doing biowater. But anyway, thank you so much for this great day. And because it's just, this is like an inaugural, right? According to the secretary. I think that we'll draw many lessons from this inaugural Moot Court, Firmwide Moot Court. I'm sure the next one which will be planned, I would like to appear as counsel in some way, not as an administrator. Thank you very much. I don't know if Claimant has anything more to add, or the secretary, if she has anything to say.
Yeah, Dr. Kabinga, if I can go first, and I don't intend to say a lot. Apart from saying I wholeheartedly agree with all the sentiments that you've expressed about how the parties performed. I think it was in the oral argument together with the written submissions, I think that they were of a very, very good quality. I think you can all be proud of yourselves. And I know that this is not an area, that many of you would have been exposed to before this. We are all thankful that you decided, to be brave and to take this on. And I think you will see with the benefit of hindsight now that, it's really not that complicated, but it's just that, parties tend to use words which are foreign to, common law lawyers and stuff like that. But once you really get into the meat of it, you see that it's like all the things that we would ordinarily do from a domestic perspective. And there is quite a big shortage of African lawyers in this field. So if there, anything that we did here today or in the course of your preparation, piqued your interest and it's something that you would like to pursue further, please, do so. You will find lots and lots of articles on these investment decisions. That's how you generally get into the field, and who knows what could happen. But it's also one of those fields where you could invest quite a lot of your time into it and nothing may come of it, but it's still an interesting field nonetheless. And if you are interested, I'd really, really encourage you to, get involved in some shape or form. We really need African lawyers. As Dr. Kapinga said, sometimes when you see these matters and, there are African lawyers involved, your Solicitor General, Attorney Generals, you say, but guys, why aren't you briefing your local firms? And the retort will always be, but, they don't have experience. That's why we'd rather go to the foreign law firms. But as I think you will have seen, from your experience of this thing, that it's really not that complicated. And even those foreign lawyers, they had to start somewhere. So well done to all of you. And I don't look forward to having, to deliberate with Dr. Kapinga as to what is the appropriate decision. It might be a draw, and Bianca might have to break the tie for us. And with that, Bianca, over to you.
Thank you very much. Nothing from me, just a great big thank you to you all for a fantastic morning.
Thank you. And I think with that, we are done. All right. Thanks. Bye, everyone. And
Thank you very much, and bye-bye.
Yeah, and thanks to everybody who joined to watch us. We hope that we didn't bore you too much.
Thank you, everyone.
Thanks, everyone.
Thanks, bye.
Thank you, everyone.